Welcome back. Well, the Delhi High Court's recent decision to suspend former BJP MLA Kuldeep Singar's life sentence in the Unnao rape case has sparked massive outrage, with many questioning the Central Bureau of Investigation's handling of the case. According to court documents accessed exclusively by CNN News18, the CBI admitted that an MLA isn't considered a public servant under Section 21 IPC, which impacted Sengar's sentencing. The agency didn't support the victim's 2019 petition to try Sengar under more severe IPC charges, citing they were not squarely applicable. The trial court noted the CBI's investigation was unfair, disadvantaging the victim. The victim's family alleges the agency colluded with Sengar to suppress evidence on her age, producing fabricated documents. The case, remember, raises concerns now about the CBI's role in ensuring justice for victim and complexities of prosecuting powerful individuals. Let's quickly give you a lowdown. Let's talk about the three moves that CBI must explain in the Unnao rape case, and then we'll put out the exclusive documents we've accessed here as well. But the first big takeaway is legal formalism over victim justice. Was this prioritized? Instead of contesting the spirit of accountability, the CBI leaned on a narrow technical argument that an MLA is not a public servant under Section 21 IPC, fully aware that this would weaken the application of graver charges under POCSO. The question being asked here is, did CBI prioritize legal defensiveness over the survivor's right to strong prosecution? The second big takeaway, and the question being asked, is that the investigation marked by bias and not neutrality. Is that what's happened here? The High Court's own record is damning, which is the trial court found it an inescapable conclusion that CBI's investigating officer failed to conduct a fair probe, which leaves us with the question, is the victim justified in alleging active collusion, suppression of age-related evidence, and the introduction of fabricated documents? The third big question we ask, and this is the question that is being spoken of, institutional support when it mattered the most. Is that what's happened here? When the victim sought in 2019 to have Sengar tried under more stringent provisions as a public servant accused of rape, the CBI refused to back the plea, arguing charges were not squarely applicable. Which brings us to the question, did the CBI's refusal, noted by the High Court, effectively leave the survivor battling not just the accused, but the CBI itself? I do want to go across to Aman Sharma, who joins us with all these exclusive documents. Aman, tell us, what have we found out and why does this raise such serious questions?
Well, Kritswin, see, the CBI is now saying that they are going to file an urgent appeal in this matter, and that urgent appeal declaration came last night after the Unnao rape victim had met Congress leader Rahul Gandhi. Before that, the CBI sources were saying they are still studying the judgment, but now they say they're going to challenge the judgment. But what has really happened during the course of this entire matter, in the High Court, in the trial court, raises big questions upon the CBI. Number one, the main stand that the High Court has taken to suspend the sentence of Mr. Kuldeep Singh Sengar is that he is not a public servant. If he is not a public servant, the aggravated sexual assault section of POCSO, which is Section 5C and Section 6, will not apply to him. That is the main contention, and that is why he has got the let-off in this particular case. Now, look at what the CBI says when it argues on this matter in the High Court. I'll quote from here. The CBI says, tackling the contention raised by Mr. Sengar that he is not a public servant for the purposes of the POCSO Act, and this is right from the court judgment. We are not quoting from anywhere else. We are quoting right from the court judgment. This is what the CBI told the High Court, that tackling the contention raised by Mr. Sengar that he is not a public servant for the purposes of the POCSO Act, the learned special public prosecutor of the CBI has submitted that even though it has been held by the apex court in a particular case that the MLA is not a public servant as defined under Section 21 of IPC, it is for the courts to adopt the principle of purposive construction. So right at the onset, the CBI is saying that yes, there is a Supreme Court judgment earlier which says MLA is not a public servant. So the main prosecuting agency in a way is already agreeing with the appellant, which is Mr. Sengar, that MLA is not a public servant, but it is appealing to the court that to adopt the principle of purposive construction and still consider him as a public servant. Of course, that did not cut any ice with the High Court, and that particular POCSO sections of 5C and Section 6 have been struck down by the court, virtually making Mr. Sengar a free man unless he is, there's another case in which he's still in jail. But in this particular case, he's virtually a free man because he spent more than 7 years, and the only section High Court said applies to him is Section 3 of POCSO. That is the number one thing. Number two, I would like to point out to you what the victim told the Delhi High Court during the course of this High Court hearings. The victim said and put the CBI into big trouble, saying that even after the investigation was transferred to the CBI, the fairness and the impartiality were not ensured. So this is the victim expressing a complete no confidence in the CBI, saying that even after the investigation was transferred to the CBI, fairness and impartiality were not ensured. In fact, the victim has gone ahead to make serious allegations against the investigating officer of the CBI in this case at the initial stage, saying he was in collusion with Mr. Kuldeep Singh Sengar. Now, that is a very, very serious accusation by the victim's family, and that has been captured in this High Court judgment. The faith that the lack of faith, I would say, rather the victim has in the CBI has been captured in this particular judgment. Another very, very damning aspect, Kritsween, which I want to highlight to the viewers, that in 2019, maybe the family had an inkling that such charges may not stick. The victim's family then went to the trial court saying that additional sections of the IPC should be put on Mr. Sengar because they said it's a public servant, and these additional charges under the IPC are put on him. He will face a stiffer sentence. But guess what happened? The CBI ignored this. The CBI even, in fact, in the trial court objected to the addition of these additional charges, and that also finds a mention in the High Court judgment. I'll quote from that the trial court dismissed the victim's appeal and said that the above order dated 20th August 2019 passed by the learned trial court was not challenged by the victim but was not supported by the CBI. And if you read this particular order of 2019 of the trial court, where the victim's family was asking for graver charges against Mr. Sengar so that he stays in jail for longer, the CBI said, this is not our case, we will not support it. So these three major questions marks arise on the CBI because of that stage in 2019. If the CBI had backed the family in putting these additional charges, maybe today Mr. Sengar would not have been, sentence would not have been suspended at all. But these are very, very serious charges, and CBI, I think, has a lot of explanation to do on why it acted in the way it has in this particular case.